colleagues this morning by the members of portfolio committees from Public Works and Defense who are joining in on this matter as we try and find convergence for collaboration on the issue, given that it's cross-cutting, so that there is no duplication of activities and resources as part of effective and efficient oversight. So, colleagues, I welcome all of you this morning. So I think because the meeting is very straightforward, from our side, we met with the Department of Public Works and Infrastructure on the issues of the Beitbridge border post fence. We expressed our concern about the processes around procurement, and also the fact, well, that the fence does not seem to be fit for purpose, and that the costs of it are astronomical in comparison to what is on the ground. Colleagues will remember that 21 million rands had already been paid of 37 million rands. What we received at our last meeting was that the further payments had been frozen. The minister requested the AG at our last meeting, so we'll hear from the AG. At our last meeting, it was brought to our attention that the SIU had also conducted an investigation, and that National Treasury was and the matter stands now is that we were scheduled to have an oversight to Beitbridge, and I'm advised, of course, at the time we kept postponing because of the lockdown. I'm advised that the Portfolio Committee on Public Works and Infrastructure has set into motion a process for a program of oversight, which I would suggest we look into, and as part of the collaboration, we join in. But we will get those details. The chairperson of the Portfolio Committee has been in touch with me, so we will finalize that particular one, colleagues. So what I will do, we welcome the Minister and the Deputy Minister of Public Works and Infrastructure, Minister Delil and Deputy Minister Kivit. What we'll do is we're going to hand over to them to give us their presentation, and then National Treasury will come in. I saw the DG is present, and then we will proceed to National Treasury, to Auditor General. I would request that we are mindful of time, because the sitting of the House is also scheduled for this afternoon. So, Advocate Mutibi, I will hand over to you and your team to take us through your presentation. Ms. Ntombi and Butben, please enter the apologies as we have received them into the record. All right. Advocate Mutibi, over to you.
Thank you. Thank you, Honorable Chairperson, honorable members, colleagues, and other honorable members in the meeting. Honorable Minister, I saw the Minister is in attendance. I'll open up, Honorable Chair, and I'm attending with my colleagues, Mr. Leonard Lekgetho, who is the Chief National Investigating Officer who was overseeing the investigation. And with us is also Mr. Johnny Leroux, who's the Forensic Investigating Officer, is actually the project manager who project managed this investigation from our side. In attendance from our side also is Dr. Wells, who's the Chief Legal Counsel. This matter is also on its way to the Special Tribunal, so he's attending so that he could appraise the committee on where we are with this matter going to the Special Tribunal. We would like to make sure that it ends up there speedily. Honorable Chair, without further ado, this is the matter that was brought to our attention by the department itself. They contacted us and brought the issues to us and indicated that they would like SIU to assist the department in the investigation of the irregularities relating to the border post in Beitbridge. In fact, it's the current acting DG who contacted me at the time, and we put in motion the process to enter into a secondment agreement, which we do as SIU in terms of our legislation, particularly Section 3, subsection 6 of the SIU Act allows the SIU members to be seconded to state institutions to assist. And then we entered into a secondment agreement which effectively saw the kickstart of our collaboration and assistance in this investigation. We did that, and the presentation today will appraise the committee in terms of our investigation, our outcomes, and some of the actions that have been taken. With your permission, Honorable Chair, I'll hand over to my colleague, Mr. Lekgetho, to proceed with the presentation. Thank you very much.
No, that's fine to you. He may proceed.
Thank you.
Thank you, Honorable Chair. Thank you, Honorable Minister and Honorable Deputy Minister and Honorable Member present and colleagues. I'm going to do the presentation as outlined there. This slide just talks through the index of what we're going to discuss, which will be the background, scope of the investigation, general findings of the investigation, recommendation, and conclusions. As the head has just outlined, on Monday, the 16th of March, 2020, ministers issued a directive to the Director General of the Department, directing him to appoint service provider using emergency procurement process in relation to the erection and repair of borderline fence at the Beitbridge border post. The directive from the minister referred to Section 27, subsection 2 of the Disaster Management Act. And according to the minister, the purpose of issuing the directive was to secure the border in order to prevent the spread of COVID. Still on the background, and on the 25th of April 2020, the minister requested the department's anti-corruption unit to conduct the investigation in the procurement process, followed by the erection of the fence. DPW approached SIU for assistance, and members of SIU were seconded to the department. The investigation commenced on the 28th of April 2020 after concluding the secondment agreement between the SIU and the department. And I just need to indicate that this was the collaboration between the SIU and the department anti-corruption unit member that conducted the investigation. Dealing with the scope of investigation, we were to determine whether DPW followed a fair and transparent SCM processes as prescribed by Section 217 of the Constitution during the appointment of the contractor and consultant. And we also determine whether any feasibility study was conducted for the services of erecting the 40-kilometer fence. And we also were to determine whether there was any value for money and whether the work performed were in line with what the client's department, which was SNDF, requested, and also to determine whether there was any criminality and if the SIU could consider motivating for a proclamation. Remember, during this time, the proclamation was not issued. We were going to investigate to see whether we cannot get a proclamation in order to investigate this matter in detail. General findings on the investigation are as follows. The investigation revealed procurement irregularities perpetrated during the infrastructure delivery process, as well as possible acts of fraud. The irregularity identified include irregular application of emergency procurement, irregular appointment of the contractors and the principal agent, the effecting of an advance payment of 21.8 million to the contractor and 1.8 million to the principal agent within days of their respective appointments, and was irregular as no material was delivered and construction has not yet commenced. The department failed to test the market in this regards to at least determine the reasonableness of the contractor's price. The procurement framework of bid specification, evaluation, adjudication was not properly followed. National Bid Adjudication Committee, who adjudicated on the appointment of the PA and contractors, failed to ensure that proper SEM process were followed. The appointment of the contractors was predetermined, and the above-mentioned process failed to achieve the objective of a competitive, transparent, reasonable, and fair procurement process, making it irregular in terms of Section 217 of the Constitution, as well as Treasury and departmental regulation in this regard. An assessment conducted by the professional review team of the item in the bill of quantities, drawings and specification, and the work as built indicated that they were not aligned. The assessment also found that the fence is not in compliance with the drawings and the specification. The value for money assessment conducted by the PICC technical task team indicated significant anomalies. The total project cost, which includes both construction and engineering fee for the contract, was 40.4 million. Although the contracted amount was ostensibly calculated at 2016 prices based on an earlier contract, the evaluation indicated that some of the items quoted were in fact not based on the 2016 prices. This includes site establishment cost exceeding 1 million, which should not have been charged, an excessive unit rate for specific item. The assessment found that the overall total project cost should have amounted to 26.1 million, was therefore overpriced by 14.3 million. An assessment using market-related price for material actually used on-site and revised fee for engineering service provided for a total project cost of 23.3 million. This indicated the project was exceeded by an amount of 17 million. No proper review of the bill of quantity was conducted by DPW, and this consequently resulted in the contract price being inflated. This also reflected the real risk of the DPW of having failed to test the market. The 2020 market comparison also indicate that the price of 2016 rates were also inflated during the time when it was made. Poor construction practices compromised the effectiveness of the fence as a deterrent for crossing the South African border with Zimbabwe. The barbed wire coils were stretched beyond its recommended effective limit, also making it easier to scale the fence. These factors undermine the effectiveness of the fence to mitigate border threats. The significant elements of the border fence project were not implemented at all. For example, the design of the fence had a final height of 2.2 meters, and the final actual height of the fence reached not more than 1.8 meter height on either side of the border, making it more easier scalable. During the SIU visit on the 4th and the 5th of May 2020, we recorded at least 115 breach of the fence, which may have resulted in an untold number of unlawful crossing between South Africa and Zimbabwe. The construction of the fence is also in material breach of the condition of the Provisional Site Clearance Certificate, PSCC, including breach of environmental regulation, as well as deviation from the approved line of construction. Given the non-compliance with aspect of the design specification and poor construction practices, the fence is no fit for purpose, and current payments in this regard may already be regarded as fruitless and wasteful expenditure. When coming to a recommendation, in our report, we recommended that disciplinary charge have been recommended against 14 senior officials of DPW as a result of range of alleged act of misconduct perpetrated mainly during the procurement and construction phase of the border post. It is also recommended that the department should register a criminal case of fraud against the principal agent, main contractor, and designated official for misrepresenting the DPW that the project progress was achieved in order to justify a progress payment when this was not the case, and for financial misconduct where appropriate. The principal agent and main contractor must be restricted from doing business with government subject to the application of relevant due process. It is recommended that DPW should report this material non-compliance with environmental law and to consult with the Department of Environment, Forestry and Fishery so as to correct non-compliance in this regard. It also recommended that principal agent fail to act in the interest of department and accordingly breach their fiduciary duty towards the department. And it is therefore recommended that their conduct accordingly be referred to Council for the Belt, Environment and Engineering Council of South Africa for further investigation. DPW must ensure that appropriate training is conducted and awareness is created that the system of governance that regulates the activity of department has not been suspended as a result of COVID-19 related emergency. Supply chain management should use the appointed service provider to conduct due diligence on tender processes. Any further border fence initiative should be located in the context of this program in terms of an integrated national strategy, best practice and border management master plan, duly aligned to and noting the recently signed Border Management Authority Act of 2020. In conclusion, Chair, I just need to indicate that DPW has started with the implementation of the recommendation from the report, and SIU is approaching the special tribunal in order to cancel the contract and to recover the loss that has been suffered. That is all from us. Thank you, Chairperson.
All right. Thank you much. Advocate Mutivi.
Thank you very much, Chair. Just on the last slide, as I indicated when I opened, Dr. Wells, who is our chief legal, is in the room. He can actually unpack that last line that indicates that SIU will be approaching the special tribunal. The matter, as I indicated to the Honorable Committee, was conducted based on the secondment, not under the proclamation at the time. Now it is the proclamation is in place, so we had to make sure that our legal standing, it's normally referred to as the standing which would allow us to bring the court matter, which is called locus standi. We had to make sure that there's a legal basis and our legal footing is sound. So I would like to just get the Dr. Wells to indicate, firstly, what have we done? Where are we? What are the timelines to get to the special tribunal? And this would be to firstly to ensure that the contract is cancelled and ensure that there's recoveries that needs to be made on behalf of the department. Thank you. Dr. Wells?
Good morning, Honourable Chair, members and ministers. Just in line with what Advocate Matibi mentioned, is that we had to just clarify and obtain a legal opinion concerning the legality, which involved basically the following: that the SIU can then litigate based on the evidence obtained whilst the SIU was on secondment. We've obtained that opinion now, and we're quite confident that the SIU can act on behalf of the department as well as its own name to institute the necessary civil remedial action. We have been advised by counsel that the appropriate action at this point in time, there is a basis to set aside the contract. In her words, it is a nullity. That means that the contract is void ab initio based on the irregularities that was determined or established during the investigation. The second leg of it is the ascertainment or determination of the quantum, because there has been, to a certain extent, some delivery that needs to be clarified in the next process. So to just answer the question as Advocate Matibi set out, we've obtained the opinion. We have the green light to proceed with the litigation. Council have now, as discussed yesterday and this morning with her, she's requested a consultation with the team. That would be scheduled for tomorrow morning at 9 o'clock. We anticipate that papers should be ready by next week, the latter part of next week. If all the outstanding requirements, which as I understand it now, the determination of the valuation of performance, but I believe that the team is quite confident that that will be met. So in terms of timelines, I can confidently say that we will probably issue papers then by next week, late next week, in the special tribunal. Thank you, Honourable Chair. Thank you, Advocate Matibi.
All right, no, that's fine. I think we can proceed then if the SIU is done. National Treasury.
Thank you, Chair. Good morning, Honourable Chair, honourable members, Minister, Deputy Minister, Advocate Matibi, and colleagues. Thank you very much for the opportunity that you gave us to come to the committee. I just want honourable members to indicate circumstances. You know, if you look at the presentation from the SIU, would have been first, and maybe and then the SIU does do some work, and finally there are recommendations. One understands that the agency of the called for all of us to work together. Now you will notice that some of the findings are almost exactly the same in terms of what we based on what the SIU has already investigated, which is something that we're recommending right after doing a desktop review, call it that for now, Chair, a desktop review of documentation that we received from the Department of Public Works and Infrastructure. So this is not in any way an independent work that we did on our own. We basically assessed the bid adjudication, bid evaluation process, and also assessed any type of documentation from the department that will have made this, review possible. So, Chair, as you can imagine, I'm with a team here from the Chief Procurement Office, Estelle, who is the acting accountant, acting Chief Procurement Officer, and Gendry, who essentially who essentially did the review on our behalf to try and get to the details of this. So we've got a very short presentation, Chair, which is almost repeating some of the things that the SIU had picked up. So if you can allow us, Chair, to just go quickly through that presentation, because we basically looked at it from a different angle, whether the procurement process were followed, whether there was any type of flouting of the procurement processes, and then we come with what I said can be seen as being superfluous in a way, because we are recommending that an investigation should be done. And however, the SIU has already almost at the end of the investigation that we are recommending. Let us to take us through the presentation quickly, and then we can then answer questions later. Thank you.
Right, no, that's fine, DG. I think she must take us through the presentation thoroughly and not quickly, so that we can get the different perspective which you're speaking about correctly. Because as indicated, we wanted to make sure that from all the material vantage points, Parliament is fully appraised. So she may proceed.
Thank you, Honourable Chair, Honourable Members and Minister. I will take you through the perspective of the National Treasury based on documentation that we've received and the bid review that we've done. So going straight into the presentation, in the background with regards to this procurement transaction, on the 16th of March, as my previous colleague had indicated already, the Minister of Public Works issued a directive in terms of Section 27(2) of the Disaster Management Act. And this directive was issued to have emergency procurement procedure undertaken with immediate effect in relation to the erection and repairs of border fences, of which the Beitbridge border post was a priority or one of the hotspots that was identified. The Minister's directive had the conditions as listed there. Firstly, that a project team had to conduct a site visit with the contractor by the latest of 16th of March to undertake due diligence, secure the brief and personnel needs, as well as determine the provisional costs and the timeline for the construction. Also, the appointment of the contractor had to commence by latest 20th of March. Further, the condition also stated, or some of the conditions stated, that the CFO of DPWI shall be advised as to the cost in order to secure the provisions for the emergency variation order, and that the CFO must put emergency mechanisms in place for the payment of the contractor to be done weekly. The DDG, construction management, had to then identify competent site managers, one per site, to be permanently on site during the rollout of this emergency construction, and that one program or one project manager would be identified to be responsible for the oversight of the entire project. The delivery progress report shall also be provided to the Minister and the Minister of Defence, Minister of Public Works and Defence on a weekly basis. So those were the conditions of the directive. So when we look at what is concerning to the National Treasury is those underlined words or underlined concepts that says the CPO shall be advised as to the costs. And here we can say that costs are determined as an output from the site visit assessment, after which a bill of quantity is then drawn up. Furthermore, we're talking about the variation order, which means that the assumption is there that there's already a contract in place, which you cannot vary something that is not there. Payment on a weekly basis to be made, and what worries us is the fact that it's a weekly payment. and the payment should be based on services rendered against a bill of quantity. So just to brief the members of the provisions of emergency procurement, it's coming from Treasury Regulation 16A 6.4, which states that in a specific case, if it is in a specific case impractical to invite a competitive bid, the accounting officer may procure the required goods or services by other means, provided that the reasons for deviating from the competitive bidding process be recorded and approved by the accounting officer. Further to that, it is unpacked in Practice Note number 8, 2007 and 2008, which further states that should it basically repeating 16A 6.4, but it further says that if it is impractical to invite the competitive bids for a specific procurement, the accounting officer may procure the required goods by other means, such as price quotations and the reasons provided. Practice Note 8 further also states that if such a transaction is above R1 million, that transaction is to be reported to the relevant Treasury and to the Auditor General. In a subsequent instruction note 3 of 2016-17 that talks about the abuse of supply chain provisions, paragraph 8.4, it has a clear definition of what emergency procurement means. And there I'm just going to read that it states that an emergency procurement may occur when there is a serious and unexpected situation that poses an immediate risk to health, life, property, or the environment, which calls for an agency to action, and if there is insufficient time to invite a competitive bid. So further, we also from our review saw that the National Bid Adjudication Committee approved Magwa Construction on the 18th of March in the amount of 37 million to provide the contractor services, and that on the very next day, the 19th of March, the Adjudication Committee appointed Prof Team for professional services to provide the professional services. So our findings, honorable members, is that Magwa Construction was appointed for what seemed to be a continuous service, and the fact that they were appointed for an unspecified period makes the emergency procurement transaction disputable and can therefore not be deemed as emergency procurement. The scope of the work was determined at the site inspection, and therefore the appointment and the scope of work of the professional team is not clear, as the specifications were already available, and we therefore assume that their services would not have been required. It also seems to us very plausible that Magwa Construction drafted the bill of quantities on behalf of the DPWI, and then responded to their own bill of quantity. In the event that, it is evident that Magwa Construction submitted their bid proposal prior to the completion of the report of the professional team, which brings the costing of 37 million into question, which we've seen now in the previous presentation. In normal circumstances, a professional service provider would be appointed, and those are the engineers, the quantity surveyors, and so on, to conduct the assessment and then draft the bill of quantity on which the RFP or the RFQ would then be based for the contractors then to make their proposals on. So in this case, we saw that Magwa Construction submitted their bid proposal prior to the appointment of the professional team. The National Treasury could not determine the reasonableness of the costing, but I think our colleagues from the SIU did a good job there. There is evidence that that indicates that the bid adjudication's decision to appoint both bidders were based.
No evidence.
Oh, sorry.
There is no evidence.
There's no evidence that the BAC's decision was based on justifiable or reasonable grounds, taking into consideration that the scope of work was determined at the site inspection. We could also not, based on the absence of clear commencement and expiry dates on the contract, we could not ascertain what was meant by short and medium term. From the SPD4 declaration form, we could also not determine whether the shareholders or the directors are state employees, I think because they were talking about trustees. We also could not get confirmation from the CFO with regards to this. It is also not clear which contract the minister was referring to when she gave instruction for the variation of the contract. The correspondence from the minister referred to the variation order, but did not provide a description of the order or the details of the contractor. But it would seem that the minister had a contractor or a supplier in mind already. The National Treasury is aware of previous contracts at the specific border post. It is therefore not clear whether there was an existing service provider and why the DPWI did not utilize the service provider or providing the service or the current service. We are not sure whether there is a current contract in place. So if we look at the service, it's to continuously maintain the border post, and it seems to me that this the fact that it's a continuous service, that the urgency and the emergency of this service is also now questioned, because it's supposed to be a continuous service and not a once-off. Furthermore, in one of the documents submitted by the department, it indicated that both Magwa Construction and Prof Team were approached with the intention to issue the variation order after receiving the request from the minister. If the consultant and the contractor were approached after the ministerial directive, it also poses then the question as to the purpose of inviting the other two consultants and contractors, the VCE for professional services and Hillside and Asatico to the site inspection. The invoices paid to Magwa Construction also does not make provision for the items on the bill of quantities that were completed, and the grounds on which the completion certificates was signed off is also not known. The DPW indicated that the final payment could not be made due to the investigation process. The department failed to indicate when this instruction was received, because that has a bearing on the payment of the 21 million, whether it was prior or post the instruction. And it was also not clear what the scope of work was for the outstanding amount and whether it relates to the fencing. In terms of the separation of powers, the executive authority must not interfere with administrative functions. Although we indicated there was no clear indication of a start or an end date in the contract itself, the minutes of 19 March stated that the contract commencement date is the 18th of March, which means that the contract took effect at the site inspection prior to the appointment being approved by the Bid Adjudication Committee. So this transaction may be deemed as irregular. So as DG indicated, that our recommendations are now going to be over or under, how do we say this, DG, that it's superfluous after the recommendations made by the SIU. And I will pause there. Thank you. Thank you, Chair.
All right, thank you very much. DG, are you good?
Thank you very much, Chair. Yes, we are good. There is also a detailed, over and above the presentation, we also provide a detailed 30-page basic review that we did, that honorable members can also look at in terms of some of the details that are still summarized in the presentation. So the presentation and the report should be read together for completion from where we were able to review this process and make our recommendations on. Thank you very much, Chair.
Well, that's fine. Note that. All right, colleagues, I'm advised that the work of the AG has not been complete, and therefore we shall await for them to indicate to us when they that work is done. So I think we have received a comprehensive presentation from the SIU, and it was important for National Treasury as well. I think they have given us a valuable vantage point to the work. So I'm going to, colleagues, I've got Honorable Dirks, Honorable Mente, and Honorable Lees. To the colleagues joining us, because we usually indicate speaking here on our WhatsApp group, which you may not be party to. I will request that after those three colleagues, you will just indicate. I see the Honorable Olomisa will be number 4. Honorable Hadebe. All right, Honorable Hadebe, and then Honorable Mahau and Honorable Graham. All right, we'll take that first round. We'll proceed in that fashion. Honorable Dirks, you first off the bat.
Good morning, Chairperson. Good morning, other honorable members present. Good morning, Edward Modibi, National Treasury, and other officials present. Good morning, Minister. First, let me just thank and congratulate Advocate Modibi on the good work and outstanding work that he's doing in fighting the scourge of corruption in this country. And we appreciate your report. We really appreciate the report and the work you have done so far on this PPE of defense, border fence. But I want to raise an issue here, Chair, that I am concerned about the directive from the minister to that department. And allow me, Chair, to read that directive. The directive starts off by including conditions. Firstly, starts off by including a directive that includes conditions. And let me just read this directive. The project team shall be led by the TTG Construction Management, together with a senior person from Defense who is to urgently arrange and be responsible for the logistics. Shall have a site visit with the contractor by the latest Wednesday, 18 March 2020. To undertake the due diligence, secure the brief and personnel needs, determine provisional costs, identify the emergency construction timeline. That is the first part of the directive. Then 2 deals with the contractor shall be appointed by the 20th of March. Then 3 again, the CFO DPWI shall be advised as to the cost in order to secure the provisions for this emergency variation order. Further, the CFO shall put emergency mechanisms in place for payment of the contractor for work undertaken on a weekly basis. 4, the DDG Construction Management shall identify competent site managers, 1 per hotspot, that will be permanently on site during the rollout of the emergency construction. Further, there will be one project manager identified who will be responsible for the oversight of the entire project and accountable for the delivery in terms of the emergency expenditure timeline. 5, which is the last directive from the minister. A delivery progress report shall be provided to myself together with the Minister of Defense on a weekly basis. Now, my concern with this directive, it is extremely prescriptive, this directive. And bear in mind that when this directive was given, there was a DG in that department. But the directive is going to, is identifying certain officials and saying the DDG infrastructure construction shall do this. This one shall do that. So it's more than conditions that was attached to this directive. It was actually prescriptive to say who shall do what on the project. And that is my concern with this directive. And the National Treasury have raised the issue, and I've raised it before, the issue of the administrative processes, that politicians cannot interfere in administrative processes. Now, this directive is actually giving directive in administrative processes. A directive goes to the head of the department, which is the DG, to say that this is the directive. The DG then must implement the directive and follow all the relevant administrative processes. It is not for a politician or for a minister to give that kind of directive to say this official shall be doing that. And that's my concern with this. Was very prescriptive, this directive. And today we get the report from Advocate Motibi that we must hold officials accountable. Politicians, ministers must be held accountable for wrongdoing that is taking place in their department. Must hold all ministers accountable for any wrongdoing in their department, especially when a directive like this was going out to that department. And then lastly, Chair. Now, before lastly, I want to know from Edward Motibi, have they looked at this directive? Have they interrogated this directive? Have they questioned this directive? Have they investigated this directive? And know from Edward Motibi that. And then lastly, the minister then gives the last directive saying that there will be a weekly report back to her. Now, when all these wrong things were happening, when upfront payments was given, when all that, was the minister not informed on a weekly basis? Because she said, I'll have weekly reports. Where was the minister? Where was the minister when all these wrong things that are now identified was taking place? Because she was on top of the game here, she was on the ball here. She said, I want a weekly report. I am saying, Chair, that the buck cannot stop simply by certain officials in the department. The buck must stop by the minister, especially if the minister has stepped into the administration. We must hold ministers accountable in the 6th Parliament. And Minister Delil must be held accountable for what happened in the department. And so will we do in all other departments where ministers have overstepped the line. We have to draw a line in the sand. Corruption, we must root it out, we must stand against it, we must draw that line in the sand. And here today, we must draw that line in the sand. We must hold the minister accountable for what took place in that department, because she was directly involved with the directive. Thank you, Chair.
All right, thank you very much, Honorable Dirks. The minister is present and she will provide responses. And also to the SIU, the question is very pointed insofar as the issue of the directive is concerned, right? Honorable Mente.
Thank you, Chair. Chairperson, the first thing I want to talk to is the Treasury report. In the Treasury report, I am not convinced that they did everything that they were supposed to do. It's not a conclusive report in a sense that, one, when they talk to the variation and the instruction of the minister, the lady says they are not sure if there was a contract in place. They are not sure of the variation order instructions. And for me, it gets to say they didn't do what they were supposed to do. Couldn't they have asked the minister, was there a variation order instruction? What was the contract available? What was the standard of the contract? And then they come and tell us what must happen in terms of the Treasury regulations. 2, the bid proposal. She is reporting like it seems the bid proposal was done by the company itself, and the prescripts thereof in terms of quantities were prescribed by the company, not came from DPWI. That is very problematic. But at the very same time, it's not conclusive. It's something, if she must correct me if I'm wrong or I heard her wrongly, is that conclusive that the company proposed its own quantities? The company proposed its own. It wrote, it gave out orders in terms of what should be the prescript, and that was accepted by DPW without the DPW outlining its own prescription of the proposal in terms of quantities. So National Treasury, please give us a conclusive report. What is wrong that was done between the company and DPW in terms of breaching the Treasury regulations and the PFMA? That's what we want to know. Secondly, Chair, I want to check, SIU has spelled out a lot of irregularities. Now, in the previous meeting, I think it was in March, June, if my notes serve me right, when DPWI was with us, we asked specifically who was responsible to sign off the due diligence. Because in that particular document, you ought to then know all the specifics. Is the company fit? What are the quantities we're looking for? What's the quality we're looking for? What is the time frame we want for delivery? And what kind of work we're looking for? Who signed off that particular document that the company was fit and proper? Because without that person, we cannot hold any other person accountable. Because a person convinced the whole department, or a team convinced the whole department that that Magwa company was fit and proper, pricing was correct, quantity correct, quality correct, time frame for delivery correct. Who signed it? Who convinced them? Because that's the person who must then account. Now, another point, the 21.8 million advance. Who signed it off? Who was convinced by who to pay an advance on something that is not there, or on something that is not the department was looking for? Don't just pay money on something you don't know. Then there are prices that were inflated. And then the problematic area for me is the fact that even the scripts that they are relying on in terms of pricing, which they say they made comparison and used the information of 2016. 2016 in itself, SIU says it was inflated. the 2016 one. Now, when it comes to the 14 officials that the SIU has identified, one, Minister, out of these 14 officials, did you go back to check the wrongs of 2016 as well? Because SIU would have already told you that even the basing of your logic on 2016 prices, which were also inflated, were supposed to have been investigated by now. And you were supposed to have used whatever method available to ensure that your pricing now is correct. Now, out of these 14 officials, the person who was there for 2016 and responsible for those, is he or she part, or are they part of the 14 officials? And out of the 14 officials recommended for disciplinary action and criminal procedures thereof by SIU, how many are undergoing such? And if there is anyone who's not part of that, why? Lastly, Chair, in terms of criminal cases, we want to know how many criminal cases you've laid against all of them. Where is the company today? Have you started a process of getting the money, all of it, from the company? I see the SIU is recommending a tribunal where they are going to work towards stopping the entire contract. Did you already start a process of stopping that contract when we told you 2 months ago that freeze payments? Ayikho lento eyenziwe eBeitbridge. We can't have a fence that is 1.8 meter for a fence that was supposed to be 2.2. That's already broken, holes everywhere, has nothing, doesn't resemble anything that looks like a border fence. Thank you very much, Chair.
All right, thank you very much, Honorable Mente. I hope the colleagues are taking comprehensive notes. Honorable Graham has swapped with Honorable Liz, so we'll take Honorable Graham now.
Thank you very much, Chairperson. I'd like to really welcome the National Treasury report. My concern with the SIU report has been that the focus has been on the officials in the department, and they've kind of glossed over the whole issue around the directive. The directive is very, very clear, and the instructions given by the Minister in the directive are very, very clear. The National Treasury background slide actually errs in one point where it says that the Minister requested that they appoint a contractor. The Minister in her directive stipulated to the contractor. I've asked on several occasions about the Minister's involvement in the procurement around the fence, particularly with respect to the fact that her advisory staff were part of all the discussions around the appointment of the contractor, the site inspections, etc. So I'd like to welcome the fact that the National Treasury have identified the directive as the starting point of this entire process, as opposed to the SIU investigation being the starting point. One of the questions I have is that the SIU were appointed, and in various meetings we've been advised that the Minister requested their intervention. I have a copy of a letter from the Auditor General, from the Director General, in which he complains to Advocate Matibi on the 20th of June this year about the involvement of the SIU and their intervention in the DPWI. So I'd like to know who it was who actually requested the SIU to investigate in the first place, because according to this letter, the accounting officer and the Minister were not aware that there were officials seconded from the organization to undertake work in the Department of Public Works and Infrastructure, and they were also not aware that there were officials from the organization assigned the responsibility to investigate the Beitbridge border fence maintenance project. And I'm quoting directly from the letter. In light of this anomaly, we therefore distance ourselves from any report which may have been submitted to the official of the department as mentioned above. So I'd like to know what has been done to address this whole issue. And also, I'd like to say that at the end of her presentation, the member of the National Treasury said that she felt that their report was superfluous. I disagree in that this report of the National Treasury now highlights the fact that there was ministerial intervention and there was ministerial interference in the procurement processes that happened around this project. Thank you, Chair.
All right, thank you very much. The Honorable Olomisa.
Thank you, Chairperson. Can you hear me?
You are audible, sir.
I won't take long at all. President Ramaphosa on the 23rd of August this week said that his party, ANC, may not stand alone in the dock, but it does stand as accused number one. Perhaps he was concurring with his former cabinet minister or colleague, Nomvula Mkhwanyana, who told Zondo Commission that Bosasa was supporting and working with us in the ANC. Now, given these admissions, should SCOPA not consider endorsing an action where the SIU should not only investigate the corrupt individuals and tenderpreneurs, but that it also follows the breadcrumb trail to establish whether any illicitly gained make even for other ministers, because this so-called political directives are not only surfacing today. We have seen them, and they have messed up the whole administration. Thank you.
Right, that is noted. Honorable Hadebe with an H.
Thank you, Honorable Chairperson. Chair, I want to state it categorically clear. When the department appeared before us, based on the presentation given to us, it did not need a rocket scientist to ascertain, Chair, and confirm that this tender or procurement was predetermined. This, Chair, is based on the sequence of events as it was highlighted in the presentation that was made by the department when they appeared before us. In that meeting, Chair, I stated very clear and official that involved in this document wanted to honor this contract and consulted by all means possible, Chair. It was even evident when they asked the very same contractor to draft the bill of quantities and the scope of work for them. And as such, this scope of work was even drafted before the National Treasury issued the instruction on emergency procurement. Hence, they wanted to appoint this very same contractor on a variation order. When they saw that their ways are not going to suffice, they immediately aborted the variation order mission when National Treasury the following day introduced the instruction in a form of the emergency procurement, and they then went ahead to appoint the very same contractor. I then asked in that meeting, given the constitution and the requirement of procedural fairness, the issue of competitiveness, the issue of ensuring equity, even if you are dealing with emergency procurement, do they think that this tender followed all procedural fairness and what they did was rational? The answer was yes. They did not hesitate to say to us, yes, they think they've done everything according to the issues of procedural fairness. I also ask minister and the officials, did we receive value for money given the quality of the fence, given the amount of money spent? The fence was meant to be 2.2. We are told now it ended up being 1.8. Yet the report indicated that there was site inspection both by the project managers and the officials from the department on daily basis. The question is, what were they inspecting on daily basis and compiling a report on a weekly basis to the minister if they could not ascertain that the height has been reduced from 2.2 to 1.8? Chair, I would like to get an understanding whether all these officials that are involved, are they still within the department? Are they still responsible for the procurement processes and bid evaluation committee? If yes, Chair, they need to be suspended with immediate effect. They cannot continue when they came for us. But it was evident even though we could at the time conduct our oversight, but we already mentioned and highlighted that here we smell a rat. That fence, Chair, does not even qualify to prevent chickens from crossing over from Zimbabwe to South Africa. Yet we were told that we've received value for money. The fence, it's what it was meant for. Now, this thing of officials coming before us, and when we raise questions and we give evidence to them, they are adamant and think that we do not know what we're talking about. It must come to an end. I would want to move, Chair, that if they have not been suspended, it will be not fair from the side of the department, including the public, to allow them to continue with work as usual. They ought to be suspended with immediate effect until all disciplinary processes are concluded. The last issue, Chair, is in relation to the scope of work of the SIU, which also include determining whether any feasibility study was conducted for the services of erecting the 40-kilometer fence. I did not get a sense or an outcome whether or not they've arrived to a conclusion that indeed the feasibility study was conducted. But this is very strange that a department would ask SIU to ascertain or investigate whether or not a feasibility study was conducted. This is the matter and an issue that's supposed to be known to the department whether or not a feasibility study was conducted. You can't be, when you're a responsible department, not know the contract that we have awarded and the tender that we have given to private contractors. You have conducted feasibility study. I find it's very strange and awkward. I would like to get a sense and an understanding. Why would they even ask an outside agency to tell them whether or not they've done what they were supposed to do? Thank you, Honorable Chair.
All right, and on that note of the chickens, we'll go to the Honorable Mahao.
Thank you very much, Chairperson, and good morning to all. Let me first thank the report from the SIU. I'll start first with the SIU recommendations. Truly speaking, as much as they are really clear, but they are quiet about the intervention of the minister, knowing exactly that separation of powers are supposed to be implemented there. So why is there no mentioning of what would happen to the minister, knowing exactly that the minister has intervened administratively, of which that must not be the case? Coming to National Treasury report, I appreciate that report, but as Honorable Mente alluded to, that report is incomplete because there are no clear recommendations about the interference of the minister. So National Treasury must go back and again find out the contractors of 2016. What happened to those contractors? Coming to the minister, I've got some few questions. That is the minister not aware of separation of powers? Why the minister is interfering because it is an admin work. So what interest had she had minister for her to intervene there? And again, is the minister not aware of the legislative provisions of emergency procurement? Why this has happened in the health department? Thank you very much, Chairperson.
All right, thank you very much. Honorable Liz.
Mr. Chairman, thank you, and good morning to everyone. Mr. Chairman, I just start through you to Advocate Matibi. Advocate Matibi, you must be tired of coming to our committee, but we really do appreciate the enthusiasm which you do that. The chances of recovery of this money, what in your opinion at this stage are the chances of recovering anything, if at all? And have the asset forfeiture units started taking over assets? Then you talk about 14 senior officials who are recommended to be charged. Who are they? And specifically, is Melissa Whitehead one of those officials? Mr. Chairman, to Minister Dillon. Minister, it's quite clear that this contract has been completely delinquent right from the beginning. And it seems that there's sufficient evidence that your participation in the workings of this contract were fairly deep-seated. This contract has cost the country a huge amount of money, but even more so, the objective of protecting our border from the COVID virus certainly was not met. 115 breaches are reported by the SIU in a very short space of time. So it is quite clear that there's been a delinquent actions or lack of actions on the part not only of the officials, but also on your part, Minister. Minister, will you resign and take the consequences for your part in this delinquency? Thank you.
All right, Honorable Swartz. Suspenis.
Thank you, Chair. Good morning to all members. Chair, I've just got a problem of a bit of load shedding. I think if I put on my camera, I'll be disadvantaged. So I don't.
No, that's fine. You can proceed because you're quite audible, so that's fine.
Yes. Chair, mine is on that I'm very surprised that today we are sitting here again and we are getting presentations when the department came before us. They swore by the Bible that everything is in order and everything is fine. And today we are sitting here.
Honorable Swartz, just 1 minute, just 1 second. There is a colleague whom is got their mic on and they're calling Ulinda. They please turn off their mics so that they can discuss with Linda in private. Right, Honorable Swartz, you may proceed. Honorable Swartz, you may proceed.
Thank you, Chair. Chair, I am saying that it is very disappointing that everything today points to the involvement of the staff in the Minister's office. Because, Chair, maybe they would like to also give us answers on the following, that why the Chief of Staff in the Minister's office, Roger Solomon, led the delegation for inspection at Beitbridge, because that already was interference in the project. 2, Chair, the secretaries, both of them in the office of the minister, were part of a meeting, which in their first presentation to us, they did not mention. That meeting, Chair, was a meeting where they decided how they're going to procure in the most convenient and quickest way. So I will agree with Honorable Liz when he's asking if Melissa Whitehead is still in the minister's office to date, because they need to give us a report, Chair.
where the department must be very honest and include all the people in the minister's staff who were involved from the inception up until the end, because even when they went to meet South African Defence Force on the 17th of March, which is the same day which they did a site inspection with the contractors, where the principal agents and the contractors were waiting for them. Even there, the senior secretary, was the one leading the delegation to go and do the site inspection with South African Defence Force, and where he cut the meeting short in that the contractors and the principal agents were waiting for them. So the department must not play hide and seek with us, Chair. The minister's staff must be put on the table as to why they were so much involved from step one to the last step, in terms of procuring quickly, in terms of leading delegations for inspection, whether it was on a basis of that they are doing it on behalf of the minister, but why would the minister be so much involved in a procurement process to put up a fence, which at the end of the day, we have all repeated so many times. I think Honorable Bheki Hadebe forgot to remind them that in their presentation, they gave us photos of 2017 when they presented to us in the last presentation on the Beitbridge. They never ever gave us photos of 2020. I don't know, honorable members or chairperson, whether you did get any updated photos, because those were one of our questions where we requested that I myself asked the question that was the project manager managing the Beitbridge on Zoom, and how were they taking photos? How did we end up with photos of 2017 when they procured now during COVID and the emergency, using the quickest and easiest way? Chair, I've got many questions under this, but I think at this stage where we are, with what Treasury is giving us today and the SIU is giving us, I think that the department must also start giving you a report, Chair, that will clearly outline the involvement, unless they want us, Chair, to again call them and step by step tell them how they actually implemented this project. Thank you, Chair.
You were muted, Chair.
Oh, thanks, Mazambane. Honorable Mkonto.
Thanks, Chair, for this opportunity. Good morning to colleagues and our guests. Chair, I will start with the presentation of the department. In their introduction, they said they will speak on investigation, outcomes, and actions. But unfortunately, Chair, I did not hear the actions. It is not clear as to exactly what has already been done, specifically to the individuals, the alleged maladministration and finance mismanagement is directed to. And I did not hear, Chair, the role played by the DG as the accounting officer. I listened very carefully, but I couldn't hear as to what was the role of the DG. Is he part of the 14 officials or what? And then I'm very puzzled by the fact that there is a lot of outsourcing done. The bill of quantity, the scope of work, the project management, is the department without officials that are assigned to do this type of work. does the department have a project management unit or not? Because seemingly everything was outsourced, and a lot of money has been spent instead of using the human resource available to the department. The National Treasury talked about blacklisting the companies involved. Chair, in many cases, companies are being blacklisted but the people owning those companies, they go back to the CIPC and register other companies and continue doing work with government. So from this matter onwards, can the SIU please check if they say a company is that a company does not do work, is people, is individuals who do work, can their focus be on the individuals being blacklisted instead of just names of companies, and people are given an opportunity to come back and do work with government? Thanks very much, Chair.
Thank you very much. So there's very detailed questions on the part of members. I will request that the responses are pointed to the question so that we avoid meanders and be very frank. What I'll do is we'll start with the minister, then we're going to go to the SIU, and then National Treasury. So we'll proceed in that fashion. Minister Tilo, over to you.
Thank you, Honorable Chairperson, Honorable members, the SIU also, and National Treasury. Yes, I also want to thank the report that we received from National Treasury and also from the SIU. Colleagues, honorable members, I do want to be held accountable. I will never run away from accountability. I do have a respect for the public of South Africa, and I will work even harder. But I do have to remind members about the history of this department. And you're all aware, you've been members of parliament, you've seen the annual reports, you've seen all of the allegations around the funeral stamps and all of that. Honorable Chairperson, since I arrived about a year ago, I've introduced various systems like consequence management, contract management, introducing due diligence. But of course, like the members say, the buck stops with me. And I must be held accountable. Yes, I must be held accountable in terms of certain provisions of the Act. In terms of the Public Finance Management Act, honorable members have to look at Section 38 of the Public Finance Management Act, read together with Section 64 and Chapter 7 dealing with the executive authorities. It must be read together. But it must also be read together with Section 85 of the Constitution. And Section 85 of the Constitution deal with executive authorities of the public. And under C of point number 2, 85 2C, it says, the executive authority, together with, it starts with the executive authority is vested in the president, and the president exercises this executive together with the members of the cabinet. And then it says C, coordinating the functions of the coordinating the functions of the state departments and administration. Now, members speak about interfering in the process of procurement. On the 15th of March, the President declared a national state of disaster. In that national state of disaster, number of borders of the country were closed, and what was brought to our attention was the about 40 kilometers of the over 700 kilometers of the border between ourselves and Zimbabwe. On the 15th, there was a meeting. It was attended by the Director General, attended by the DDG of Construction Project Management, and they worked out the timeline and the content of what can be done to respond to the emergency. The Director General then provided the timelines and the content, which I have included into the Director. So as we went on, Chairperson, I did receive not weekly reports, but daily reports of what is happening at the border. And I want to again today say to all the colleagues that when it comes to the implementation and when it comes to procurement, if there's any evidence that I have personally benefited from this particular tender, then please, you must bring the evidence. I am prepared in terms of the constitution of this country and Section 38 and Section 34 that my role is also to hold, as an oversight, to hold the accounting officer accountable. So yes, the acting DG will speak to some of the technical part around disciplinary matters. In terms of disciplinary matters, as far as it goes to the 14 officials, my role as the minister is to report any wrongdoing or alleged wrongdoing of the Director General. That is my responsibility. And that is what I must do and will be doing. In terms of the officials within the department, the accounting officer will take charge of the disciplinary processes there. With Beitbridge, when I became concerned about some of the reports, not only from the public, but also some of the reports that we have received, I immediately, on the 20th of April, contacted the Office of the Auditor General and asked the Auditor General to do a independent audit. On the 25th of April, I also instructed the Anti-Corruption Unit to do an investigation, and the Anti-Corruption Unit was assisted by the SIU, and I want to thank Advocate Motibi for providing the secondment of two officials. We've also brought in the Presidential Infrastructure Coordinating Task Team to help with the technical parts of the investigation. I then took it a step further by asking and requesting that the department, DPWI, stop any further payments to this company. And that also happened. And today we are happy to report, because I believe in transparency, I believe in openness, that we need to report to the honorable members of parliament to hold us to account. And certainly, like I said, I do want to be held account. We owe it to the public. And it's because I want to be held to account that I have initiated this processes of investigation. And like I was saying previously to the other portfolio committee, and the acting DG will speak to the implementation of the recommendations, that now that the President on the 23rd of July has issued the proclamation that the SIU will now continue to, like they have reported to us this morning, to handle the Beitbridge issue in terms of that proclamation. and we will await the outcome of that work, Advocate Matiba. I think I've tried to just summarize everything, Chairperson, and I will ask the Acting Director General, with your permission, later on to deal with the technical aspects of the investigation. I thank you, honourable members.
All right, no, that is fine. We will get to the acting DG and colleagues. I suggest let's take all the responses so that we get a full picture of what is said. And then I note that there are follow-ups that you want to do. So we'll come back to that and tie it down with the department. So let's get the SIU, Advocate Mtivi.
No, thank you very much, Chair. We appreciate the opportunity again. Let me also just start with the last point that the Minister made. We indeed have the proclamation, and ordinarily, in the normal run of our investigations, we do take into account the evidence that we gather at the time of the investigations. But it does happen that new evidence come up either at the tail end of the investigation, and we are implored, we are duty bound to take into account that evidence. It does appear from the presentation that we've received, there might probably be a particular need for SIU to interact with the National Treasury to just look into this possible evidence that indicates any irregularities, and we will now take it forward in terms of the proclamation, and look also at the provision of Section 64, because the Section 54, if I recall it in so many words, is that it does provide for executive authority directives that have financial implications. But however, it goes on to say if the directive has a potential to cause irregularities, then the Director General or the accounting officer has got some responsibilities. But we will look at that and then pronounce ourselves now under the proclamation. With regard, I want to deal also with the questions raised by Honourable Graham Murray with regard to the letter that was sent by the Director General. I am aware of that letter. It was sent to me, and I was really caught unaware, to say the least. I was surprised that that kind of letter would be written to the SIU. Works and infrastructure under so many proclamations, and we have had dealings with the DG and with the acting DG now. And the acting DG has always been the nodal point or the contact person authorized duly by the department to deal with SIU. So over the years, SIU has been dealing with the department based on the due authority that has been given to the DDG. When I was approached and called by the DDG, it was also in that context that he is duly authorized to approach the SIU and request SIU on behalf of the department to conclude the secondment agreement. I responded to the DG. I can find my response letter to the DG and send it to the committee, where I also expressed the similar views that the acting DG now has been the authorized nodal point of the department. And he acceded to that. And I said to him, at no point did the DG ever indicate to the SIU that they've got now a changed arrangement, there's now a different person, or the authority that was given to the acting DG, the now acting DG, has been withdrawn, and now we must deal directly with the DG. At no point, and the DG, in his subsequent letter to me, acceded to that, and he said, "Okay, we will now, from now onward, deal with me directly." And I understood that there is no problem at all. The context of that would then be that he would have withdrawn the authority that was given to the acting DG, and we would deal directly with him. So that's the context of those interactions and the letter that the honourable member referred to. The Honourable Dept, the issue around the SIU investigation, I think I covered it when I started. We will definitely look at those administrative arrangements, in particular the directives. But during the investigation, my colleagues who are in the meeting with me, they did conduct interviews, including interviews with the Special Advisor to the Minister, and amongst others, some findings were made, but I indicated to them that should there be any evidence that come up, we will definitely be implored to have to look at that, and now that we've got the proclamation, we will have to do that. The other questions that relate directly to the SIU or out of the honourable mentor, yes, indeed, we've spelled out the irregularities. Yes, I would really imagine that the department would be in a better position to now indicate who signed off on the company to be fit and proper. But our investigation would also have revealed that out of the 14 officials, the findings have been would have been those who authorized several processes irregularly, and we have made specific findings. At this stage, I would really want to indicate, and at our last appearance, Honourable Chair and Honourable Members, SIU was asked to release the report to the committee. I'm glad that the department is in this meeting. I interacted with the acting DG. My plea would then be that because this is the department's report, it was done under secondment, it becomes the department's report, unlike when it's done under proclamation, which becomes the president's report. In this regard, I think the department should really be asked to consider releasing that report. Honourable Holomisa mentioned the issue around the directives, and I did say that we will look at those. Honourable Mahau, the report being quiet about the intervention of the minister. I think as we have indicated, is that the evidence that we gathered thus far pointed to certain officials, but it appears now that there might be the new evidence that we have to look at, and we will look at that in accordance with the proclamation. Honourable Lees, and I would like to also invite our chief legal, if need be, but I would like to say in our civil litigation process, when we set out to recover, we do, of course, make sure that there are opportunities to recover, because we do not want to come back with a hollow judgment. So therefore, if for example, if we'd like to recover money and there's no liquid cash, we look at the assets that that can be attached. And the question raised, we're working with the AFU. Yes, we've got a continued interaction with the AFU, but our rules and regulations are regulating the special tribunal. The SIU now has got also those powers to institute restrained orders. And the orders of restraint would include freezing assets, forfeiture, and so on. And we've been doing that lately. The legal team is looking at that as a matter of urgency. The question of the officials, I just don't have the names now, but I do know that in the report they are spelled out quite in detail. And the question was specific whether there was a name that Honorable Liz mentioned. I think it's the we did find make some findings against the special advisor to the minister. We did make Honorable Mkonto. We made findings that related to the DG. We made findings relating to Director Special Projects, Acting Chief Financial Officer, Acting Head Supply Chain Management, members of the National Bid Adjudication Committee. So we did make findings relating to those. Chair, I would like to pause here and perhaps allow our colleagues and the National Treasury to make input. Thank you.
Thank you very much. National Treasury.
Thank you very much, Chair. So we had two questions directly to us, but I'll comment on those, and Estelle can come in again. Honorable Graham Murray was saying that what we are saying, we are not saying the report is superfluous, so the whole report is unnecessary. No, the only thing that's unnecessary is that we are recommending that an investigation should happen. In that way, we're saying the investigation has started. So that's the only part where we're saying maybe unnecessary. So just in so the recommendation of the investigation was started, but the report remains relevant, and I think it must be treated as such. Now, in terms of Honorable Mentor's points, to an extent, the Treasury or in this work, we did not do everything correct, because we do such reviews, Chair, all the time, whether asked or when we see as a matter of public interest, we do them all the time. The intention here is not, and we don't have the power, not the capacity, not the mandate also to get deeper like the SIU do in terms of taking the matter through to its logical conclusion if there's evidence of any criminality or so. We don't have that. But what we did, as any of our reports, and I emphasized a desktop investigation or report that we reviewed that we did, which was essentially to list all of those points that we listed as issues that an investigation, which we recommend, should take into account in terms of all of the issues, whether a variation order was received or whether the processes were followed to the letter, or whether there are any acts of criminality or so, that the investigation will pick up in terms of what is expected and what was needed. So there are, for instance, instances where we are saying that, the bills of quantities were, the 2016 bill of quantities were used, that were used. And we're saying in 2016, the report, the bill of quantities was by performed one of the technical professional service providers. So we are saying that if in 2016 this bill of quantities was done by a professional quantity, a consultant, and the same quantity consultant were appointed in 2020, we're saying there may be a conflict of interest, and this is all in the report as part of the preliminary report or review that we did. So if we have to get deeper into the investigation, that's what we recommend. Now, in two ways, we can either do in two ways. If this conversation suggests that an in-depth investigation should be done, then obviously we will put in motion or if the department does not have the capacity to do that, like we picked up in some of the reports that we do, we find that the department does not have the capacity. Then we institute, then the OAG, the Office of the Accountant General with the specialized audit services, then comes in and a detailed investigation then is undertaken. And in that case, the forensic, once undertaken, then can be passed on to other relevant authorities in the state that are entrusted with that responsibility. Now, the difference here is that obviously there's a proclamation by the president of the SIU to get involved, and that's why the SIU is in the room now. In that way, it then makes sense for the SIU in their investigation, Honorable Member, to then get into the details of all of the points we are mentioning here if they did not already touch on of those issues. And that's why I think Advocate Mutibi then is saying it then becomes necessary for us to engage with them on specific matters that we may have looked at and on specific matters that require further attention in terms of whether there was any act of wrongdoing or if any of the provisions of the instruction notes and the practice notes were not followed. In that case, then the investigation can then determine whether the expenditure is fruitless, wasteful, or irregular, including then the point that then makes sense as then what corrective actions or consequent management actions must be taken. And if maybe we close the circle here and the AG was on the call or was on this, you would have picked up that the AG then would have then made a determination whether this is fruitless or wasteful based on the evidence that they would have looked at. So for the purpose of this review report, we were not, the intention was not going to do everything in what was expected, because that's not what we saw as critical at this point in time. What was critical was that we must lift obvious issues, and we did lift those obvious issues, and we then recommend that an intensive investigation should then be, commended. But if the committee then over what the SIU is doing, we must then conduct a further forensic investigation, which is in depth. Then obviously we'll look into that, and we wouldn't, not do it if we were instructed as such. But we think the SIU is already on it, and we wouldn't want to duplicate efforts that are already put in place. Estelle, I don't know if you want to come in and touch on other matters.
Thank you, DG. I think you covered most of it. I also just wanted a statement about it's only the recommendation for investigation, to conduct an investigation that was superfluous. But I think you covered most of the questions that was posed. What we can do, however, is on the questions that Honourable Member Mente mentioned, is to go and maybe just for completeness sake, look at those questions that you posed and adjust our reports accordingly.
All right, no, that's fine. Colleagues, I just want to make a proposal, but so before I do, I'll consult it with you shortly. Is to say, I heard Advocate Mutibi listing some of the people whom they made a finding against. Was the finding made against the minister?
Honorable Chair, in the report that was handed, there is no finding against the minister.
Well, then I'm going to flag that. That's fine, thank you. And then to National Treasury, you brought in something which was making reference to the minister. If you could speak about that in one of the slides. Just can't remember what slide number it was.
Estelle, do you want to come?
Yes.
Yeah.
I think from the minister's directive, and as sorry, let me just get my thoughts. And as Honourable Member Graham Murray indicated in the directive, it talks about the contractor and not a contractor makes us believe that there was already a contract in place to which the minister was referring to, which we did not also could not gather the information to see whether either Magwa or Prof team was the current service providers, and that was what she was referring to. I think if that is the question that is posed. The other issue is the minister's segregation of duty, where she is not supposed to interfere with administrative functions of the department, the separation of powers. Sorry.
Yes, but don't you think that you having issue with the minister's directive and the lack of clarity should in itself prompted you to investigate? That on its own should have prompted you to do so, because that is the basis upon which this entire transaction has happened. So to make an assumption or say you could not gather whether it was the information or whether there was a contract in place or not, as far as I'm concerned, National Treasury has in that regard dropped the ball. And that's why I'm posing the question to SIU as to whether a finding was made. Because then if the directive has not been looked into, then there's going to be no determination made about that directive. Because I'm not getting a sense that National Treasury is speaking authoritatively about that directive as a basis upon which they moved. And therefore, as you have heard, the members, almost all of them have raised issue with the directive. And they are justified to do so because you have not looked at it. I think that's the plain conclusion we can arrive at. That you have glossed over the directive, and as far as we are concerned, that was a shortcoming on your part. And so,
what we are, oh, sorry.
Now you may proceed, DG.
Okay, thank you.
Some colleagues now on the issues that they've raised, they want to come back to.
Yeah.
Yes.
No. What we are saying with the direct, we are raising it as a matter of concern, and that's why in slide we are saying exactly that. We've underlined issues that are an issue and a challenge in terms of how this was raised. And somewhere I think the report suggests that it could have been that, and you know that we had there were processes. The speed of the processes flouted some of the broad basic things that talk to those underlying issues around the payment, and as to CFO will be advised. The CFO normally in instances like this should be leading the interventions to determine the costs as part of the process to build up a work that must be undertaken. So if the CFO is going to be advised, the question then becomes by who and when what had happened. So, and we are saying a variation is only normally issued if there's a contractual agreement already. So beforehand, there is a variation order that's already in the language that's already brought in. So all we are saying is that we are lifting those issues as matters of concern. And in terms of the explanation that we're getting, obviously we can get then deeper into what those are. Now, as to whether we have dropped the ball, Chair, I would say that firstly, we were not requested by anybody to do this. And I've just said to the team, confirmed to the team that we out of public interest, and out of the manner that was raised, we took it upon ourselves to do this desktop review in order to determine further.
No. That is besides the point and substantively immaterial, because when we dealt with this matter and National Treasury appeared before us, we were supposed to have received, or you would have completed the investigation which was pointed out to us in the meeting on the 12th of June. And it's all good and well that you may not have been prompted by anyone, but it's common cause that the reason why we had called that meeting, we would have given a directive that an investigation must have been done, and therefore to issue an instruction to go for work that was already being done would have proven to be futile, and we had not received it. So I think it's immaterial who would have given the directive. The issue that is substantive is whether in dealing with the issue, you satisfied the process and you satisfied the concern. Because I'm still not getting a sense as to when you were uncertain about whether there was a contract or not, what did you do about it? I think that is fundamentally the issue. So I think those other things, yes, were well done for being proactive. That's fine. But in your proactiveness should have been then substantive, because the nub of the issue here is the directive. The members are, all of them, raising an issue about the directive. And you yourselves are raising issue about the directive and its uncertainty, but yet not telling us how you then probed that directive and its content. I think let's move from that premise. TG, I'll halt you there, DG, and ask members, because they've got follow-ups. The first.
Who is the first, Mr. Chair?
Looks like he's frozen.
I don't mind being the first.
Right, sorry about that. My network does keep crashing. Can we get a follow-up from Honorable Dex, Honorable Swartz, Honorable Hadebe, and Honorable Ment?
Honorable Mahau.
Honorable Mahau, okay, that's fine. In that order, please, briefly.
Sorry,
Honorable Dex.
Honorable Graham, please.
All right, that's fine. Honorable Dex. You are muted, Honorable Dex.
Sorry, thank you, Chairperson. Chairperson, I think that the Minister is missing the point here. Our contention here is that the directive was prescriptive. That is our contention, that directive was prescriptive. And the Act does not allow, or the Constitution allow, Minister to give a prescriptive directive to a department. The Minister must give the directive to the head of the department, which will be the DG in this case, and then all administrative processes will be carried out by that department. The Minister does not have the powers to give the prescriptive directions that you will do so, this and that, and you will do that and that. That's out of the question. And that's our bone of contention here. That's our contention. We are not, no one has alleged that the Minister benefited financially here. That's not what we are alleging here. We are saying that it is the prescriptive directive that we have a serious problem with, and that must be investigated by National Treasury and by the SIU. That's what we are saying. Then I even get more worried when the Minister responded to the Minister saying that she did not receive weekly reports, she was receiving daily reports. Now, upfront monies of millions was paid upfront even before work was started. Now, surely if there was daily reports, the Minister was receiving these reports. And that's why we are saying, therefore, the Minister must be held accountable for what happened there. Don't all the time blame officials and then we don't.
Honorable members, friends and colleagues.
Don't. Sorry about that. Sorry.
All right. Okay.
Sorry about that, Chair. Sorry about that, Chair.
No problem.
Chair, the problem here for us, and Honorable Olomisa raised it, and this is the problem we had since 1994, with ministers and departments and DGs in their departments where ministers go directly and give directives to officials in the department. Look, all of these are, honorable, all of these are raised, and we have a problem with it. And that's what we want to be investigated here, because we need to stop that. That needs to come to an end. Ministers must not be involved in the administrative processes of the department. So that's all what we are saying, and we want the directive to be investigated. Thank you very much.
That's fine. I will make a proposal in that regard. Honorable Swart. Honorable Swart is beneath.
Thank you, Chair. Chair, all I want to raise is that nobody said the minister benefited in anything. All we are asking is that the minister can't also at each and every committee meeting, Chair, want to remind us of acts and what she is allowed to do and what her powers allow her to do. What we are asking here about today is 100% of involvement of members of staff in her office in the Beitbridge procurement of the fence. And that is why I keep on repeating, Chair, that they must give us a report with the dates of the different meetings they held. And if the minister deems, Chair, that all those meetings attended by her staff members and her chief of leading the delegation to the Beitbridge to go and check before handing over to the contractors, if it means that part of those powers she is talking about is that her staff members in the form of Rogers, in the form of Whitehead, in the form of which are her secretaries and her chief of staff, if it means that those powers means that they are the ones who are supposed to lead delegations to Beitbridge to check on her behalf, then we should be told so, Chair. Because then Treasury must outline what is it, and the SIU, especially the SIU and Treasury, to tell us that when they say that they have a hint of what they are not putting properly on the table of interference from the minister, they must tell. But where I am seated as Chair is that we can't at every committee meeting that the minister does not answer questions directly. Because questions that are put to her by the committee members, she does not answer directly the minister. Instead, the minister wants to remind us what powers have been bestowed on her. And every committee meeting, the minister wants to tell us that she is not benefiting. Nobody in this committee said it in English or Afrikaans and in any language that the minister has benefited from everything. All we are asking a question in relation, they presented us to us before, and what they are giving us now in the form of reports after an investigation. So somewhere there are cracks, Chair, where both SIU and Treasury must go back so that bezenento evuthiwe. Manje akalumeki lamazambane alihlaza, Chair. Thank you.
All right. Can we get the Honorable Hadebe with an H?
Thank you so much, Honorable Chair. Let me make a follow-up on my initial question, Chair. But to also start with the following, I would like to get an understanding, when did this report lay its hand in the department? That's number one. Because my question was, the minister, when she's responding, she's saying the accounting officer will deal with the officials involved. The report is clear, it's recommending disciplinary charges against 14 officials. I then ask a question, are these officials still within the department? Are they still responsible for bid evaluation committees? Are they still responsible for issuing tender? Did the department not see it fit to suspend them with immediate effect, as you did with your Director General, as we've seen in the case of Gauteng Provincial Legislature, where the MEC asked for a leave of absence, as we've seen with the spokesperson in the presidency who asked for a leave of absence, And if this department is serious about corruption, one would have thought by now this official would have been suspended with immediate effect. So I'd like to get a clear understanding, and if they have not been suspended, you tell us why. These are the very same officials who appeared before us with a straight face when we asked them, did we receive value for money? They said, yes. We asked them, is there nothing wrong untowards this tender? With straight face, they said, there is absolutely nothing wrong with these tenders. Now, those officials, they did not show any sign of remorse whatsoever. They can't be, if indeed they have been suspended, still wandering around adjudication tenders within the department when we have this damning report and evidence before us. I know you as the minister that does not take nonsense. I applaud you to do the honorable thing, and excuse my French, honorable minister, but I would have expected you by now that you would have acted accordingly as it has been displayed by others, your counterparts, that they take absolutely zero tolerance when it comes to corruption. And lastly, when are we expecting to get a full report? This report should be in our disposal as soon as yesterday. So I'd like to get a sense and understanding from your side whether or not we'll receive the report, and we'll get a sense of who are these officials involved. Thank you, Honorable Chairperson.
Right, that's fine. I think the oversight was on my part. I should have gone back to the DG because those substantive questions around would have been about staff. You know what the minister had said, so we will give the DG an opportunity to speak, right? Honorable Mende. Honorable Mende. All right, let's proceed. We'll come back to her. Honorable Liz.
Thank you, Mr. Chairman. What I failed to do earlier was say hello to Dondo. I miss you at our committee meetings, as we used to see you so frequently at Finance, and we don't see you much here. So welcome to Scopa from me. Mr. Chairman, Dondo is indicating that he doesn't want to duplicate the work with regards to a forensic investigation with the SIU. So I think that's a valid point. However, I would like confirmation that it's not going to fall between the cracks. So Advocate Matibi, will the SIU conduct such a forensic investigation, or should SCOPA recommend that National Treasury, through the Accountant General, undertake such an investigation? Mr. Chairman, the question of the report that Advocate Matibi quite correctly says is owned by the Department of Public Works and Infrastructure, is somewhat problematical. I understand where Advocate Matibi is coming from, but we have a history, unfortunately, of even where committees require reports to be submitted, and I'm not referring now to the SIU, in other instances, those reports are simply not sent to us. I mean, we got an example, for instance, of the Minister of Public Enterprises, Pravin Gordhan, who has not responded to questions from this committee sent to him in May, and we're now at the end of August. And so I would like the committee to resolve, Mr. Chairman, that this report be submitted within a week. And if we don't get it within a week, we then use the powers of Parliament to subpoena that report. And we don't let it get out of our sight, get away from us. I would really ask that we do that. Mr. Chairman, finally, Minister de Lille, I'm afraid, in my opinion, as has been expressed by a number of other people, your response was an obfuscation of note. You have not dealt with the issues that you were questioned about. And specifically my question, will you resign or will you not? A simple yes or no is all that's required. Will you resign or will you not resign? Thank you, Mr. Chair.
All right, Honorable Mente is back, and then Honorable Machal and Honorable Graham.
Yeah, thank you, Chair. I don't know what I've missed. The system kicked me out.
If you duplicate, I'll let you know.
Okay. Chair, back to my question again. The acting DG, I believe, is going to speak. Minister, I understand your position very well. But to say the officials, you don't account for officials, you account for a DG. That's unaccepted. Because the moment, it doesn't matter whether the law says you only account for a DG, you don't account for officials. The moment the SIU report lands on your table, you ought to take responsibility as an executive authority and ensure and have interest in knowing, now that we've been appearing to so many committees of parliament, me taken to task myself as a minister about the Beitbridge irregular expenditure, which now has turned out that it was even a fruitless and wasteful expenditure. You ought to have a special interest in finding who are the 14 officials. They might not be directly reporting to you, but you should take special interest in knowing who's these people that they are talking about. And ask the DG who reports directly to you, what have you done? Remove them, suspend them, do whatever you have to do. Because one, your reputation, whether the law says you look into this one or that one, your reputation is on the line. You are the executive authority. You are the minister of this department. Two, the department belongs to you, whether the law, the PFMA says accounting authority, the department belongs to you. So you can't come and say, no, when you can't report about them. Even if you miss certain points, but you ought to have information as to out of the 14, this is what the DG or the acting DG told me about them. Honorable Hadebe was correct. Are they still there? That should have been your special interest to say, but these people accounted to even my team and said everything is above board. But when Parliament indicated and directed to specific areas of irregularities, they still said, no, it's correct. Which you yourself in our last meeting, you said, you are part of the people that are pushing for investigations because something is not sitting well with you. Your intuition is telling you straight that something is wrong. But today you can't just say, you can't direct us to someone to report, even if you miss information. But you ought to give us something that from my side, I ask them what have they done about the 14 people. And the second part is, SIU does not have an obligation to release the report because it's not a proclamation. Your department, by now, you should not be worried about saving people's names. It's a credible institution. SIU says 1, 2, 3, 4, 5 to 14 special findings against each and every one of them. We should know by now, Officer A This is what they did. Officer B is responsible for that. Officer C was responsible for this, and this is what I have done from my office. This is what had happened from the office of the DG or directors or whoever is responsible there. Then secondly, Chair, on my follow-up, Treasury, you are the custodian of the money of this country, whether you like it or not. Yes, you have done this out of public interest and all those things, but the fact that this thing have been coming, the minister blew a whistle herself. Something is not sitting well with me here. We saw the pictures. Chief Procurement Officer, you know what must be procured that gives an indication or an image or something that depicts a proper fence which is suitable for a border. So CPO was supposed to already read between the lines, this fence does not depict anything that can block even a chicken from crossing. And therefore, Treasury was supposed to look into it deeper. If you had seen that SIU is taking this part of investigation, you ought to dig deeper in terms of expenditure of rands and cents and comparison of pricing, which is your territory, by the way. It's you, Treasury, who gives us prescripts on how to price what, where, how. Chief Procurement Officer, you are the one. You're the custodian. Then you can't say you thought you must just play safe and this and these people are going to run away. You can't play safe. So you ought to drill down and give us something. Even before AG is gonna take forever putting evidence here and there, and we know the shortcomings of our own AG in terms of performance auditing. Because they are going to audit exactly what those officials were telling us, that here's an invoice, here's the money you unleashed from Treasury, here are the invoices, accountability is fine. In terms of how we measure the current auditing, we are fine. But in terms of the performance audit, the final product is not what is on the invoice. So you know that route. You can't really shift us to that particular. Thank you very much, Chair.
All right, the Honorable Mahau.
Thank you very much, Chairperson. I must register my disappointment on the response of the Minister by defending the position he has taken to give directive to appoint some of the officials. Whether you look the act upside down, there is no way that the executive authority can be given that directive to intervene or interfere on administrative issues. I think your advisor must really come closer to you, otherwise you will be compromised. The only role you are supposed to play is to make the point that the budget within the department is used or spent economically, efficiently, and effectively, and there is value for money. And unfortunately, you did not mention that. You just mentioned that as per the section 38 of PFMA, section 85 of the Constitution, we have the right to do so. It's really disappointing. Coming to SIU, now that there is proclamation and there is new evidence against the minister, are there any timeframes you can give us to make the point that we have dealt this matter? Thank you very much, Chairperson.
Right, Honorable Graham.
Thank you, Chair. Thanks for the opportunity to speak again. First of all, I'd like to just say that this issue has come before the Portfolio Committee on a number of occasions. And on those occasions that we've had presentations prior to these SIU reports coming out, we were advised that everything was above board and done according to spec, etc., etc. In addition, questions that we posed to the Minister in writing and in the meetings also gave us an indication that everything was above board. And the answers to these questions came through long after the Auditor General had been employed to look into this project. I asked questions on the appointment of the service provider, on the contractor. The response I was given was that the contractor was appointed because they are already established on site at Beitbridge, and that there would be no financial implications in terms of the site establishment, and that they had scheduled rates which had been supplied in 2016, and on that basis the pricing was done, and also that that the scoping was done for the project on the 17th of March 2020. So the responses we were given as to the appointment of the contractor were based on the fact that the contractor was already working at Beitbridge Border Post on another project. So again, that references the directive from the minister where she says appoint the contractor. One of the questions I did want to ask was, in the SIU report, it references that the technical report and investigation was done by the PICC. Now, we've had no sight of this report. We have no sight of the terms of reference of their interventions. We don't know how they were appointed, who was on that task team, and we don't know the outcomes of that. The response that I got to a written question that I submitted to the minister was that the fence had been designed by an engineer. It had been built using off-the-shelf products, so there was no additional engineering that was required with respect to it. So it wasn't a specialized fence of any sort, and that it had been signed off at the end of the project by an engineer. In addition, it had been built according to the specifications of the product used. So in terms of the written response I have on that fence, everything was done according to spec and signed off, and we were still waiting. We were just waiting for those final sign-off reports from the engineers on that. So that then would have been the task, to my understanding, of the Prof team, CC. They would have had to have signed off on that. So I think that also needs to be looked into, because that would have been a role that they would have played, and they clearly haven't, because now, according to the reports that we're receiving, this fence was in no way, shape or form adhering to any engineering specifications. Thank you.
All right, colleagues, thank you very much. We're gonna go to get responses. Acting DG will give the responses that are required. I think we equal the other framed the way forward. So let's get the responses, and then we'll make proposals insofar as how we move forward. So right, let me go to the minister, and then the DG, acting DG, SIU, and then National Treasury.
Thank you, Honorable Chairperson. Thank you, honorable members. Honorable Chairperson, in terms of the staff of the minister, they are appointed in terms of Section 912A of the Public Service Act. And if they have violated any of their employment conditions, they must be treated in terms of that. Secondly, I do think, Chairperson, that I need to deal with, allegations that I don't answer questions when I do come before the committee. I certainly welcome any further investigation by the SIU or the National Treasury, because that is their constitutional mandate. And I will give my full cooperation to both entities, because we need to work together. The second point, Chairperson, and if I make a reference to certain sections of the law, it's because I am before a parliamentary committee of parliament. The separation of powers in terms of the Constitution means a separation of powers between the executive, parliament, and the judiciary. And I certainly do understand the separation of powers. I certainly welcome that all of these allegations must be tested. I think it would be good if National Treasury and the SIU test the constitutional provisions of Section 85(2)(c) and also Section 38 of the PMFA, and Section 64. Allegations remain allegations until they are being tested. And that leads me to the question of Honorable Lees. You will recall just about 2 years ago, the same question was put to me. I turned to the court and I won 4 court cases at the High Court because we are all equal before the law. We are all subject to get also protection by the law. So I'm not running away from any responsibility. In fact, I will welcome the interpretation by National Treasury, the interpretation of 85(2)(c) in the Constitution, the interpretation of Section 38, the interpretation of 64, because members of Parliament must hold us to account in terms of the laws that have been made by Parliament. So I'm not running away. I welcome, we're in a new democracy, we've got a new constitution, and as we set legal precedents around some of these issues and get the legal interpretation correct, it will only enhance accountability, it will only enhance how we need to do our work. Then, in terms of Honorable Khadebe, what I was saying, again, in terms of the law, we all be guided by the law. The role and responsibility of the minister is to act when it is the Director General only. In terms of action against people below the Director General, that is the role of the Director General. And therefore, before I'm accused of interfering again, I've asked that the Acting Director General give us a full report about what is happening, how far we are with the implementation of the recommendations of the SIU report. I will continue to answer questions to the honourable members of Parliament. Honourable Chairperson, in terms of requesting the report must be given to the members of Parliament. And the only issue, Chairperson, is that...
Listen. I'm sorry to interject.
Is that a point of order?
Yes.
Yes.
Yeah, Chair. Yeah, Chair, I think the question was clear.
Minister.
Okay, can you hear me?
I can hear
you. Yes,
you.
proceed. I want to hear the point of order. Yeah.
Yes, the minister on second occasion, she's not responding to the question. We understand that it becomes the Director General's responsibility to discipline, but the same Director General reports to the minister. Has the minister requested information on action taken by the Director General in relation to the 14 officials as a the SIU? If you had interest and
okay, right, all right. That point you made earlier, if she had an interest, let's go to the substantive question. What action steps has the minister taken as a response to the report? I think that is the question has been asked and now emphasized. Right, Minister?
Yes, thank you, Honourable Chairperson, Honourable Khadebe. Yes, I have requested information about further actions. The only difference is I'm saying that the Acting Director General is here, Chairperson, and right in the beginning, I've asked the Chairperson to allow him to give that report. I have seen the report, I have seen the recommendations, so I will request that the Acting DG give the Honourable Committee members a full briefing about the report. That's all I'm saying. I'm not trying to run away, Honourable Khadebe. Thank you for the question.
All right. The Acting DG.
Sorry, Chair.
Yes, Honourable Mentor.
When Member Hadebe raised on a point of order The minister was talking about the release of the report. She didn't finish unless I didn't hear her.
Right, Minister?
Can she finalize that point? Thank you.
Yes, Honorable Mente, thank you. I did say that the honorable members are entitled to the report. The report should not be withheld from any of the members. What I did say that we are in a process of testing the allegations, and what I will do is to share a legal opinion that we've received about the report with the honorable members. We can send it to the honorable chair. Thank you very much.
Okay, no, that's fine. I will make a determination about that at the meeting. Right, Acting DG.
Thank you very much, Chairperson and members of the committee. Chairperson, I will focus on the current status of the implementation of all the recommendations arising from the investigation. But before I go there, there were certain technical questions raised about the number of matters that were investigated as part of the procurement process, as well as the delivery of the border fence. The first issue that was raised, Chairperson, is the question of the bid proposal by the company and whether or not the company wrote its own specifications and bill of quantities. And as a result, the department then signed off on this particular project. And in response, Chairperson, I want to share with the committee that on the 17th of March 2020, the department, together with all the stakeholders, undertook the site visit as has been explained by the earlier speakers. And on the same day, the company, who we subsequently appointed as the professional consultant, and they were named as Prof Team, on the 17th of March 2020, which was a Tuesday, they developed the draft bill of quantities using the pricing in the 2016 contract at the Beitbridge border post, and they used that and they submitted that to the department for consideration. The department then gave this to the company called Magua Construction. Magua Construction then looked at it and made some adjustments to that bill of quantities and sent it back to the department, and the department then adopted it as the final bill of quantities, and it amounts to 37 million rand. Now, what is important, Chairperson, that I wish to point out is the company Prof Team that developed the bill of quantities did so before they were appointed. They developed it on Tuesday the 17th. However, they were only appointed by the department on Thursday, the 19th of March 2020. So that was an irregularity. And I think Treasury also pointed out that one of the other peculiarities is that the company, Magua Construction, was appointed after the consultant. That is normally against a normal sequence of events. You usually appoint the consultant first to develop the bill of quantities, and on that basis, you request a proposal from construction companies and appoint the construction company thereafter. Here we had an inversion of events. So to move forward from there, Chairperson, another question was raised about who signed off on all of these things and what were the circumstances. What I'd like to say is that on Wednesday, the 18th of March 2020, we appointed Magua Construction. And the National Bid Adjudication Committee then appointed the company and approved the appointment, but no tender documents or bid documents that you find in a normal tender process, as the SIU mentioned earlier, bid adjudication, bid specification processes were followed. No documents were actually served between the bid committee. It was merely a request to make an appointment of the company as the most convenient way to deal with the particular emergency. Moving over to the issue of signing the advance payment, Chairperson, what I'd like to say is that the advance payment was made within days of the award of the contract to the company before any material was delivered on site. And what transpired is that the principal agent, being Prof Team, prepared what they call progress payment number 1. And that demonstrated that progress was achieved, implying that material was delivered on site. But no material was actually delivered on site, so it was a misrepresentation. And as a result of that misrepresentation, the department then made an advance payment to almost 60% of the contract value. And this forms the basis of the fraud charges that we plan to lay with the police in due course. Chairperson, moving on to other questions that were raised. There was a question raised about the feasibility study and how that particular process was undertaken. And what I'd like to say is that no feasibility study was undertaken in respect to this particular project. However, it must be borne in mind that this Beitbridge border project is part of a bigger project of 700 kilometers along the borderline between South Africa, Zimbabwe, and Botswana. So there was some kind of high-level feasibility conducted in terms of the implementation of this project. But the feasibility for the 20-kilometer project at Beitbridge that was undertaken was not consummated at all. And that is probably the reason why the project was conducted in such a haphazard way and with the kind of consequences that we have seen. With respect to other questions I was asked about the variation order, what I want to say, Chairperson, at the Beitbridge border post, you have a repairs and maintenance contractor. It's what they call a RAM contractor. And the company, Magwa Construction, as well as the principal agent, Prof team, is the duo or the team that does maintenance at the border post. So when we speak about the variation order that was referred to by the other speakers, they were talking about using these two contractors to issue them with a variation order to put up the Beitbridge border fence. But what transpired is that in due course, there was an appreciation that the border fence along the borderline is a separate matter altogether from the maintenance being conducted currently at the border post itself. So they abandoned this variation order idea. But they had gone too far down the line in this regard, and they needed to use somebody to get this project going. So they used the two companies at the border fence, at the border post, Magwa and Prof team, and they simply called it a negotiated strategy. So all of these were irregular in terms of the Treasury regulations for procurement, and in particular for emergency procurement. Now, Chairperson, the question asked by the colleagues as well towards the end is about the PICC and how they were selected and what the scope of the work of the PICC is. What I'd like to say is that the investigation team comprising of ourselves and the SIU looked at a number of possibilities to bring on board professionals, engineers, and quantity surveys in particular, to help us with the conduct of an assessment about value for money at the border post in terms of the fence, as well as to determine whether the construction itself and the final product was in accordance with the specification. So that technical team was required to complete the investigation, and we looked at a number of options. And the easiest option seemed to be the PICC technical unit because they had the expertise, they were independent from the department, and more important to us, they also came at no charge. So that removed the need for a procurement process with our own emergency. We didn't want to go that route. So they were available and they had the expertise and they were of great assistance to us.
I just wonder, the issues you are substantively covered in the report, which the SIU has done.
Chairperson, I'll move. Yeah, Chairperson, I hear you.
No.
I'll move.
Yes, no, I'm asking, I'm not saying, I haven't seen the report. I'm asking, are the issues you are narrating actively covered in the report by the SIU to the department?
Oh, I understand. Chairperson, they are covered substantively in the report, Chairperson. I'm essentially quoting from the report in my response.
Then I asked because then if you are able to discuss the report, then I don't see why we should not receive the report. If you can narrate it, it opens. Because I think that members, as they've said, we want the report. So I wanted to gauge that so that what you say here, then we get the report and then it's something different. So if you are speaking to it, that's fine, you may proceed.
Thank you, Chairperson. Chairperson, moving on to the issue of the suspension of the staff, I must share with you all the implementation items under the recommendations. That the first one is the disciplinary action against the 14 individuals. And in my discussion with the minister and the approach we had taken, we took a decision to undertake the disciplinary recommendations with speed, with unprecedented speed, so that we give everybody their chance before a proper tribunal to defend themselves against the allegations contained in the report. And we are currently doing so internally, and we've mobilized our entire legal services chief directorate to assist with the prosecution of all these cases. But we've not suspended anybody, Chairperson. I must say upfront that we took a decision that we should give everybody the chance to defend themselves and follow that due process and allow them the opportunity to rebut the allegations or to give their side of the story, and in that context, pursue the disciplinary recommendations contained in the report. Chairperson, moving on to the other recommendations, with respect to the criminal charges.
Yes, Honorable Swartz.
Chair, I think that the department must first give us their report, Chair. Because now, instead of the DG responding to what the members asked, he's giving us the report which we don't have, which we can't see. And we can't even reference to that report.
Okay, I think though substantively and concretely, what is important is that nobody, we are being told, has been suspended. Because I thought that was the thrust of the questions, not the detailed narrative of the report. The report we'll read ourselves and pose questions accordingly, because I mean, now as you are saying, we can't reference what you're saying, we can't follow. So, but nonetheless, you've laid the foundation for us to receive the report, and we'll take it from there. But I think the issues, specific names were given, so on, Ms. Whitehead amongst others. The SIU has said that a finding was made, and so it's safe to assume that the acting DG is saying they are not suspended, they remain at work. And so we juxtapose that against what Honorable Hadebe said and the examples he gave about suspensions elsewhere. All right, so DG, I think you note what the members are saying, that we don't have the report currently, but of course it must be submitted. All right, we may proceed.
Thank you, Chairperson. Chairperson, I'd just like to, in a short space of time, just take the members of the committee through the current status of all the recommendations. The disciplinary charge, as I've mentioned, is currently being processed by our Deputy Director General Corporate Services under the auspices of our legal Chief Directorate. With respect to the civil recommendations as well as the criminal charges, Chairperson, what I want to say is that we've now obviously referred this matter to the SIU on the 27th of July 2020, and they've explained their processes within the SIU. And the criminal charges are very closely linked to the work of the SIU. The criminal charges in our report relate primarily to the misrepresentations made to pay out 60% of the contract price within 4 days of the commencement of work on site. And what the SIU is doing to assist us is to identify that beyond the principal agent who misrepresented that work was done on the project when it was not at the stage of completion, it was claimed, as well as the invoices of the contractor. We also have staff members in the department who were responsible for signing off the paperwork. Now, we've identified at least one person who may be culpable for putting through this paperwork, but there may be others. And the SIU is seeking to assist us to identify the whole chain in the business process, to formulate charges against all those who may have been culpable for this misrepresentation. So the criminal charges will be laid also concurrently with the SIU processes that are currently being undertaken. With respect to...
On a point of order, Chair.
Right, Honorable Mente.
Chairperson, the acting DG is playing shop steward. He is now an employer. If he says he is going to follow the SIU recommendations where criminal charges are concerned, why isn't he doing the same thing where disciplinary actions are concerned? because it's the unions that must say they must be given and afforded an opportunity to be heard and protect themselves, than him telling us that those employees must be given an opportunity. His is to do what the employer has to do, suspend them, remove them from the system, and set disciplinary procedures in place. Because he should be now convinced that they have breached certain laws in terms of procurement and do what the employer must do. You can't play shop steward and say you are waiting for a fair procedure, whatnot. No, the unions will occupy that space. You can't play shop steward. Do on the left what you can do on the right. Thank you, Chair.
Let's do this, because you see, I was trying to caution the acting DG earlier on. I'm going to ask him to stop there, because his big report we don't have. So unless we have the report to cross-reference what he's saying, none of what he's saying makes sense. I'm not sure whether I'm making sense now, because he's saying I'm gonna go now to the recommendations. We don't know what we have to read those recommendations in the context of the report first. So I think what transpires here is that we will get the report and then just have a follow-up then when we have looked at it. Because I'm sitting here now, it makes it very difficult to follow. I think the substantive matter that colleagues were asking was, has action been taken? And I think the response suffices when the acting DG says disciplinary processes are underway and nobody has been suspended. I think that is what we take out of it. So I think it's best that we get the report, and then when the acting DG speaks, he speaks with something we have in front of us. So I think let's leave it at that, so that we don't cause a confusion, right? Acting DG, unless there's something else on your side, I would like to move to the SIU and then to National Treasury. All right, 1 second. Honorable Swartz and Honorable Hadebe, points of order on your side.
Chair, I just want to say that having listened to what we couldn't exactly follow from the acting DG side, that when he says a technical team or a technical head led the delegation, in his report he must specify that the technical head is Mr. So-and-so or Ms. So-and-so. Because what I also did not get a response on, Chair, which I asked, was that is it true or not that the Chief of Staff led a delegation to Beitbridge before the project started? And the response was not given, whereas there are dates on which he went there, and specifically on the day they met the South African Defence Force, which was on the same day they met the contractors at Beitbridge. They did not answer that. So in his report, when he gives us the report, he must revise. When he says technical, there must be names to who are the technical heads. Thank you, Chair.
All right, that's fine. All right, Honorable Hadebe, and if we can all be mindful of time now. Honorable
Hadebe. Technology is dealing with me, Chairperson.
You are too young for that to happen to you, Baba.
But can you hear me? No, Chair, I am very
technology. You are very
no. Yes, I'm saying we're very disappointed the response from the DG. The report is clear that there are possibility of fraud, irregular expenditure to the amount over 21 million. Now, it is clear, Chair, that some animals are more equal than the other. The DG was suspended, yet the very same officials who have potential of causing fraud are still in charge, are still within the employment of the state, responsible for bid adjudication committees. How much more fraud do you want them to commit before you act? And suspending an individual does not mean you're not going to afford that individual a fair chance of representing him or herself. So what the DG is saying, that they did not suspend because they want to give them a fair chance to represent themselves, does not hold water. Suspension does not take away those rights. We are very disappointed, Chair. We must note it, and it must be recorded that it appears that some animals are more equal than the other. Why suspend the DG and not suspend the others who committed similar cases of irregular expenditure and there's possibility of fraud?
All right, I think let's do this. Let's get the report, look at the report. We will look at the process that the department is following. And then parallel to that, the department to provide us with a schedule of transactions in which these implicated officials have been involved in during this time to date. Because if they remain at work and they are processing things, we want to know what are they doing, and so that when we get the report, can it be accompanied by that to underscore what Honorable Hadebe is saying, so that we can then zoom into the transactions which they are part of. But let's get the holistic report. I think that's the substantive basis upon which we will move on. All right, SIU.
Thank you, Chair. Just to restate that we investigated as part of the secondment agreement, and at the end of it, the report becomes the report of the department. So, yeah. So in that context, if there's any different views about the report, we are welcome to shed some light if there's any inquiries or questions. And I mean to the department, that is, if the department still wants further inquiries.
Okay.
In terms of the forensic investigation, I do agree with the DG Treasury that SIU is investigating, and we've got the proclamation now. I can guarantee Honorable Lees that we will not leave anything unattended to. We will conduct that forensic investigations comprehensively. Chair, I think I wanted to just make those points.
All right.
Thanks.
That's fine. When we go to the DG, Umgangalis, Gade Bagcinana, right? DG of National Treasury.
Thank you, Chair. I didn't know Mr. Lees is my friend, but I welcome the friendship.
Oh, just be careful.
Thank you again. Thank you again. Chair, maybe we will, as we work together, we will have to understand the expectation from SCOPA, because we just moved on the premises of how we used to engage with SCOPA before. Let me remind members to at least 3 examples. Whether you're looking at the Tegeta coal contracts in the past, whether you look at and it was an issue of national interest at the time, whether you look at the IEC headquarters at the time, whether you look at the Free-Headed Dairy Farm at the time, you will notice that it started same way like this, where there was a review, and then based on the preliminary results, those were taken into more in-depth study of what exactly happened through a forensic process, and the reports at any of those instances would be made available. So I would say as the Advocate Mutibu was saying, we obviously there won't be need for us to go any further. But I Mentor's point that says, for some matter like this, we should have gone into too detail right at the beginning and addressed some of that. And if we are not getting any documentation, we should have insisted on the documentation, whether it's bid documents, whether it's minutes, etc. Because normally those are the things that we would request. But I think for now, Chair, I would maybe leave it here and say we will all make ourselves available through the details information that we have during our draft review report, and make it available to the SIU for an in-depth study and investigation and forensic investigation as to what happened here, and make ourselves available, whether it's from a systems point of view in providing payment, information, or any other matter that may assist the process in getting this matter to final, and then we can then leave it at that. Thanks, Chair.
All right, no, that's fine. I hear you, DG, but and I agree with you, but I think you must also take the perspective which we are coming from. This was one of the first transgressions or transactions of COVID which raised eyebrows and public concern. And so ordinarily would have expected that you use that one as a yardstick measure of any other investigation you would do, and that's why in-depth becomes the issue. And that's why I was underscoring the issue with the directive is an area of concern, and you have not substantively looked at it. I think that's where you come from. There's no difference. An outlook which says this was one of the first, if not the first. There was the e-government one in Gauteng as well, but this one is, so I think that's where we're coming from. So I agree we may have further in discussions and inputs, and I underscore what you are saying. If you are not receiving bid adjudication documents, in my mind, I hear you saying when you interacted with Public Works, you didn't get those documents. If I can just clarify that.
No, Chair. The details of what we've got and what we did not get are detailed in the 13-page document. No, I was just giving that as an example. If, okay. No.
Okay, no, that's fine. All right, colleagues, I think we have come to the closure, but not the end, because this is an ongoing matter. And I think that colleagues have framed the future quite clearly. We are expecting things to be done right. And so I would want to, colleagues, recommend that National Treasury performs the in-depth investigation with the State Accountant General to look at, amongst others, including but not limited to, the directive by the Minister and relevant relevant interventions which came with it. So in other words, I'm saying the role of the Minister must be investigated so that we can bring that to a logical conclusion. So Treasury, if you can within 14 days appraisers are going back to that. And I'll tell you why the issue of the directive becomes important in the role of the Minister. As a comparison, you had the Department of Water Affairs, where a large number of contracts and interventions were carried out on the basis of ministerial directives, in as much as it was provided for in law. But along the way, it caused problems in that department. And so you will understand members raise it from a historic perspective of precedence, that we have seen something similar before, where the nub of the issue is a ministerial directive. And so we need to clarify it. So DG, we are expecting you to do that, particularly also because you had raised it yourselves in your own presentation. So to provide us with that, and the minister has indicated she's prepared to cooperate. So there's no problem there. We want a report, and we will then test what you bring before us. Secondly, the report by the SIU handed over to the department, I think that process is correct. If you look at the fact that the SIU in proclamations hands over the report to the presidency, we would ordinarily then get that report from the presidency. I think let us observe that due process, that the body responsible to hand over the report to us will be the department. So, Minister, we would like that report by Friday this week, so that members can have a look at it, and in preparation for the joint oversight that we will be joining by the Portfolio Committee of Public Works, so that we go to Beitbridge next week already armed with information. That becomes very, very important. I must express on behalf of the committee the dissatisfaction, just for the record, colleagues, that the Auditor General was asked to investigate on the 20th of April. Today is the 25th of August, and yet that investigation has not been completed. That kind of slow pace in work is totally unacceptable, because it sets the tone then that the confidence we are trying to build into law enforcement agencies and other entities to move with the necessary speed will not happen. I take nothing away from what the SIU has done. I think they have moved with that kind of speed. But here, I'm just making the 20th of April, and to date, we have there's nothing either on the minister's desk or on our desk. So that leaves a very bitter taste in one's mouth. Advocate Mutibi, as of course we have interacted last week, we are giving you the necessary support, that in the context that the things that need to be done will be done. And as we said, the meeting we had last week was a meeting of pleasantries. The next one is about results, and our tone will be totally different. We have got this committee, as you have heard, members across the political spectrum. There's a zero appetite on our part for the tolerance of corruption and a lack of consequence management and a failure to move with the necessary speed. And so on that note, we expect the department itself to set into motion disciplinary processes that inspire confidence that things are being done correctly.
Indeed.
So the department must understand that we are not converting ourselves into a DC, but things must be done correctly. So we will gauge what the department is doing against the background of the report that we will receive. So I think, colleagues, as I'm saying, this matter doesn't end. The chairperson of Public Works, Mam Tobongwane, has indicated to us that there's an oversight of that committee, and so that as part of a coordinated effort on Parliament's part, we must not duplicate activities and resources. So we will be joining that oversight, and I appreciate, colleagues, that notwithstanding that it's a weekend, when we'll be doing that, you have agreed. You are indeed a Masosha, and I think it's an active demonstration of our own commitment to make sure that things get done. So I would like to, at this point, thank the Minister, Minister Delil, thank Deputy Minister Kivit, the DG of National Treasury, and the Head of Unit of the SIU, and all the officials whom have been present here. I'd like to thank members as well for your active participation. Hello?
Chairman?
Ba.
When is the oversight, part?
Next weekend to check the group.
Oh, okay.
Yeah, no, we'll discuss it. Just that it's something that officially landed on our desk this morning when I spoke to the chairperson, and so that's why it's been communicated. But there's in principle agreement that we will join on that regard. So, colleagues, I think that we are handling this matter correctly because we are emphasizing on due process. Bob. All right. So on that note, honorable members, have a wonderful afternoon and we'll see you in the sitting. Do take care and be safe. And I just want to, of course, offer condolences to the ANC Parliamentary Caucus on the passing on of another member yesterday. And of course, condolences to Parliament who advocate Mohammed. I also want to, there's somebody who's calling me, but they are not audible.
I think it's Honorable Somio. Yes,
Yeah.
he's not audible, Chair.
Yeah. So I just want to then conclude by saying, of course, we welcome Bob. All right, you can hear you now, Bakubeg.
No, Chair, just on the Auditor General and the department.
Yes.
Speaking with the AG's team had a meeting with the department because it looks like their team, which was doing work there, came before Auditor General's team got in there. And the AG found their work based on the specification that indeed what they were going to do is the same what is going to be done by the minister's team. And they found out that they can't do the same work with the team of the department. And they wrote to the department, they had a meeting with the department. So the department is aware that the AG has pulled off from that kind of work. So coming into the meeting and say the AG has not reported as yet, that's something else.
Right, no, we will discuss that when we meet. I know what you are saying, so we will discuss it. I think we will have
of the AGs. So at least certain things which are not right, let me clear them.
Yeah, no, definitely, and that's what I'm saying. That's why I accept your intervention. We will discuss it further. And I think also on that note, of course, we welcome Mam Tolashe, Honorable Ment and Honorable Somio Beck, and as they were conducting the interviews for the next Auditor General. And from what we saw, you've handled the process well, and we hope the outcome will be just as well. So colleagues, thank you very much. Have yourselves a wonderful afternoon. The meeting stands adjourned.
Okay. Thank you, Chair.
Thank you, Chair. Thank you, Chair.
Sure, thanks, bye.